It's important that I dispel some propaganda that my friends want to put out at every opportunity that they get in seeking to suggest that by reason of the fact that the MPP as a party is rising up in defense of the Constitution, attribute some symbiotic relationship between the MPP and the Chief Justice. Why? When they were up in arms during the processes for the removal of Charlotte Osei, was it because there was a symbiotic relationship between them and Charlotte Osei? Let's stop that. Okay? And he goes to say that why is it that the MP for Tafo South is the one who has filed the writ? And how did he get to know that the president had not engaged the Chief Justice before submitting the petition to the Council of State? Why? If the president had done that engagement, why was it difficult for them to put it in a statement that following engagement with the Chief Justice after the receipt of the petition, we are proceeding to submit them to the Council of State? You can easily infer from the statement that Felix himself released that no such engagement from the Chief Justice had taken place. So why is it that if people go to court, then you say that it may be as a result of some cahoots between them and the Chief Justice? That's why they go and file this application before the court.
Andy, you recall that during, just a quick one, you recall that during Charlotte Osei's matter, when the NDC were up in arms against it, your party went to the extent of even putting out a flyer, a poster, and actually saying that Charlotte Osei was at some point in time was a parliamentary candidate of the MP.
Yeah,
I
saw.
I think somewhere in the Western region or so.
Look,
I mean, I'm just trying to tell you how things played out in the past.
So they had a symbiotic relationship?
No, I'm not saying that. I'm just telling you what happened in the past.
I don't see the relevance of this information to the discourse. I'm only saying that to the extent that they believed that the process was targeted, we are entitled to believe that the process that is being carried out today is targeted. And it cannot be because there is some symbiotic relationship between the MPP and the Chief Justice. So that assertion, it falls flat on its face. Let's stop making those comments in the public space. Isn't it interesting that as lawyers, we are in a position to criticize decisions of the apex court? But today, Eduji sits here and says, who is he to question the counsel of the wise men? Hey, Eduji Tamaklo. Look, we all respect the eminent members of the Council of State, but they are not beyond criticism. Just like they are quick to criticize the Supreme Court, even as lawyers, and say that the Supreme Court is not beyond criticism.
Right.
It's not personal. I know some of the eminent members of the Council of State personally. I'm not going to sit on national TV and denigrate them under any circumstance. But it doesn't mean that if they advise in a certain manner, thankfully now that we've all seen the report, the petition and the responses that the Chief Justice issued, we cannot critique their recommendation to the president. We are entitled to do so. And Eduji, I believe that 5-6 months ago, you would have been the first if this had taken place, some time back.
Right.
To sit here on national TV and deal with the Council of State properly. So let's not come and sit here and, act holier than thou, as if to say that, we are respectful. It's not for us, like the MPP is doing, to criticize the wise men. And you mentioned the venerated Joad Jaho and the former Chief Justice. And, no, please. Nobody is going to fall for that kind of posturing that you guys want to throw in the eyes of Ghanaians. Look, Moro, when this whole process started, regardless of all the comments that the NDC had made in opposition, beginning with the elections petition, which subsequently their own national chairman is on tape to have admitted was a shambolic petition, had no basis whatsoever. Say you get here, unless of course you also haven't heard. And it would be good for you to play the tape if you have it, since members of your panel can assist in production policy. They knew that their case was empty. Yet they went to court expecting that the court was going to aid an empty petition. So they started when the applications that had held no water was consistently thrown out by the Supreme Court. Unanimous FC, name calling, back and forth, here and there. Said all sorts of things. Samahama at the NDC Lawyers Forum encouraged them that, hey, we need to have a balance on the bench. What did he mean? The national chairman is on record. The Chief Justice has to go. She has to be removed. In spite of all that they have said, I felt that, look, constitutionally, if the president receives a petition, in any event, we are told that this petition was received sometime in February. They kept it until 25th or so March before they forwarded it to the Council of State. I suspect that maybe it's because the composition of the Council of State was not in place. So I'm not going to fault them. Okay, but of course, they could have informed the good people of Ghana at the time that they received it if they were minded to that, look, we've received these petitions, but the president is waiting for the Council of State to be constituted so that he would trigger the process of submitting it. And they didn't. They kept it to themselves, and but that's fine. I said that, well, let the processes go through. Because it cannot be that the Chief Justice is above the law. I was prepared to give them the benefits of the doubt. And let the process, let's see how it plays out. Then I heard Sami Jemfi on Asempa making all sorts of scathing. Of course, at the time, we all hadn't seen the petition. Neither had we seen the responses. I heard him on Asempa FM making scathing accusations against the Chief Justice. How can you take public funds to go and buy tickets for your husband and your daughters? What is this guy talking about? I was really concerned. I thought that, well, maybe if these allegations are true, then maybe, just maybe, the benefit of the doubt that I personally had decided that let's, give to the president and the government to see how this process ends up was right. Then later in the evening, I read a post on social media by the former Deputy Attorney General, Asunaba Dapa, counteracting essentially what Sami Jemfi had said and making suggestions to the effect of some of the claims or the assertions in the petition. So I was like, where is this thing going? Then, thankfully, the following day, which was, I believe, yesterday or 2 days ago, the responses to the petition became public. I took my time to go through the document. And I was scandalized that the Council of State could look at the petition and the responses of the Chief Justice and arrive at the conclusion that there was a prima facie case made out pursuant to which a full-blown investigation ought to be undertaken. What it means is that if the Chief Justice fails to adduce evidence to rebut the issues that have been raised, it will be deemed to be true. But, Moro, you've read the responses.
Yeah.
The key issue that I see my friends hanging on relates to the travel, okay?
Yeah.
That the Chief Justice had with her husband on one occasion and her daughter on one occasion. And they say that that was irregular. How so? They point to the responses that the Chief Justice gave and says that, well, she says that she opted. Then I ask myself, so what is wrong with that? Because you read the provision, and I have a copy of the foreign travel by heads of judiciary and superior court judges, the policy here.
This entire document?
The entire document.
Okay.
I have it here.
Okay.
Remember that as lawyers, we are trained to read documents as a whole.
Yeah.
We cannot nitpick because you get the full essence of the intent when you read the entirety of the document. Remember also that the benefits that Superior Court judges get is an Article 71 benefit, commensurate in some cases with that of the President and the Speaker.
Yeah.
So are they suggesting to me that by reason only of the fact that the (9)(b), where it says that the travel expenses, where the Chief Justice embarks on a personal or private foreign travel, he or she shall be accompanied by the security alone, means that the Chief Justice can only travel with the security? Is that a suggestion? Meanwhile, if you go on official duty, she can travel with the security, her aide-de-camp, and personal assistant for official travel. So official travel, she can actually travel with 3 officials of the judicial service, plus her husband and or wife or any other person of her choice. So when the Chief Justice is embarking on an official travel, she is entitled to travel with at least 6 people. But they leave that and say, oh, well, in her private travel, she can only go with the security person. I'm suggesting it to them. And I'm not surprised that we hear that the person who recused herself from participating in the Council of State decision making is the former Chief Justice. I don't know how true that is, but it will be useful because she's an extremely public-spirited person. In fact, she was part of the people who demonstrated against the president who nominated her to the office of Chief Justice because she believed that the domestic debt exchange program, which had impacted pensioner bond holders, was wrong. And so I will urge her, it would be extremely good if indeed it is true that she is the one who recused herself, to speak out to the public as to why she did this. Because there's a clear convention that my good friends are misinterpreting. If you read the entirety of the document, on every occasion that the Chief Justice is traveling, whether official or private, she's entitled to travel with her spouse. It is only when she's embarking on a private travel that she cannot go with any other official of the judicial service than the security officer. How is this difficult to appreciate? And that is the only issue that they are hinging this entire 3 petitions and the the responses on to arrive at a prima facie decision. How short? Is that the basis? Because every other issue, in some instances, does not even concern the petitioners. It's not personal to them. They don't provide any evidence. They don't support their case with anything. So you can see that the focus of the NDC is on only this administrative matter, where the Chief Justice herself is not even a spending officer of the judicial service. So this is the basis why a prima facie case has been made, for which, if the Chief Justice does not proffer evidence to counteract it or rebut it, will be deemed to be true. Then it dawned on me that, look, maybe, just maybe, I was wrong in granting my good friends the benefit of the doubt. And that everybody else who were up in arms was right. Because this clearly suggests to every rational being who's read the documents that it is nothing but an orchestrated, predetermined process to remove the Chief Justice on account of all the things that they've said whilst in opposition. You think people should sit? You believe that? Now I want to know whether you believe that on account of this background, Ghanaians should not be concerned. And I'm surprised. You see, that he is praising the Ghana Bar Association for this statement, suggesting that they were essentially commending the president for being fair. I don't think so at all. This is a very subtle statement that, look, you may, as is usually the case, decide to go on the tangent of rule by law. Because that's exactly what they're doing. They're going by the letter of the Constitution and say, hey, well, we haven't done anything wrong. But the Ghana Bar Association is telling them that we are watching you, because in our constitutional interpretation, you cannot rely on only the letter of the law. You ought to be guided by the spirit of the Constitution. So that's exactly what the Ghana Bar Association is telling Mr. Mahama and his government. That yes, we agree with you that you may have gone with the letter of the law, but we are watching. And we will not allow you to breach the spirit of the law without necessarily saying so. But as far as I'm concerned, that's the import of the statement that the Ghana Bar Association has issued. Because I'm sure that if the Ghana Bar Association had done otherwise, we know our friends, they would have jumped and pulled the Ghana Bar Association into the tag that, they are MPP affiliates. That's why they have also jumped to the defense of the Chief Justice. So, Eduji, don't be deceived though. Indeed and in fact, this is a clarion call that we are watching with eagle eyes, and that we are not going to sit for the government to breach our constitution with wanton, purely on account of political expediency, to advance their cause of their avowed intent to remove the Chief Justice. We cannot go on this tangent. And I pray, look, it's not a question of we don't trust the judges on the panel. Not at all. But it is the precedent that you set that people can, or the processes of removing a Chief Justice can be triggered by such, I don't want to use the word empty, petition. As somebody says he's gone to court, he's been disrespected. Why? EDJ, you know, if a case is called and is being determined, every extraneous matter that does not relate to the case should be recorded in the record of proceedings of the case. Where does that find expression? And so this COP Akologo man didn't have a personal suit, and he goes and makes some statements that the court, not the CJ, finds offensive and sanction him. That activity or that proceeding that took place in the courtroom in somebody's case should find expression in the record of proceedings of somebody's case that you are not anyway related to. How does that happen? And based on that, you accuse the Chief Justice of doctoring the record of court. And you think we shouldn't criticize the Council of State for seeing this as basis for the Chief Justice to be called upon to answer? We shouldn't criticize the Council of State. Let's not do this to ourselves. Look, I've said that the people who claimed that the process to remove Madame Charlotte Osei, my sister, was wrongful, was politically motivated, and spoke against it, should be consistent. Because otherwise I will be practicing unprincipled politics. In any event, if you say that, well, you did it, and you promised the people of Ghana, and it was wrong, by the way, that the Akufo-Addo government did it was wrong, and that Ghanaians should vote for you, you are coming to reset the country, put it back on the path where things are done properly. How do you justify this activity or action that you've taken? How is it consistent with your own promise to the people of Ghana? And I'm saying that is a dangerous path, because I cannot for the life of me begin to imagine a situation where the of the Chief Justice, and by extension, potentially the entire justice delivery system of this country, becomes coterminous with the tenure of office of president. I cannot for the life of me begin to imagine that even happening. But if we go on that path, like Mr. Mahama and his government are bent on going, I'm afraid that is where this country is going to get to. Is that what we want?
All right.
I thought he was interested in setting a legacy.
Okay.
We shouldn't go this path.
Right.
And it's not because the MPP is in support of the Chief Justice. No, not at all. I believe that is the right thing to do, that we speak against the temptation. And I'll say this. It is only Mr. Mahama whose legacy posterity is going to judge. Not the hawks in this party who are urging him on, as far as the facts as we know it today, to do this thing, to tarnish his own legacy. He should do what is right for Ghana.